The legal odyssey of Egypt's cultural heritage, Antiquities trade under Sharia and state law. The issue of the antiquities trade has long been a subject of legal and ethical concern, which has undergone significant evolution throughout history. Attitudes, both legal and religious, towards the trade and ownership of antiquities have varied considerably from the Islamic era to the modern period. This article traces the history of regulating the antiquities trade in Egypt, beginning with the Islamic legal perspective, moving through laws enacted by successive Islamic states, and culminating in modern legislation under both the monarchy and the republic. The Sharia perspective on pre-Islamic antiquities. Under Islamic law, antiquities from before Islam were generally regarded as buried treasures of the Jahiliyyah, belonging to civilizations that were not founded upon monotheism. Such finds fell under the Islamic legal category of al-rikaz, hidden treasures, governed by the hadith in which the Prophet said, "In buried treasure, 1/5 belongs to Allah, and the remainder to the finder." Based on this principle, anyone who discovered a treasure or buried relic was required to pay 1/5 to the state or public treasury, under the supervision of the mutasib, market inspector. 2. Regulation of the antiquities trade in the Islamic era. The Tulunid period, 3rd century A.H. Ahmad ibn Tuluan was the first to institute an official system regulating the excavation and exploration of antiquities in Egypt, known as the System of Claims. This framework stipulated, anyone wishing to search for antiquities had to notify the state. The state was entitled to 1/3 of any discoveries, while the excavator retained 2/3. In line with Islamic law, 1/5 of the treasure was allocated to the state. The state also provided security escorts for excavators. The Ottoman era and European intervention. During the Ottoman period, the situation underwent a dramatic change. European explorers and collectors, often aided by local residents, began excavating and exporting antiquities. Their interests extended beyond artifacts to manuscripts in science, medicine, engineering, construction, and weaponry. This is why today, institutions like the National Library in Vienna hold vast collections of Islamic manuscripts, while Egypt's primary repositories remain Al-Azhar's libraries and a few mosque collections. 3. Regulation in the modern era. Under Muhammad Ali Pasha, 1805 to 1848. Muhammad Ali issued decrees to regulate antiquities sales and oversee excavations. He imposed taxes on the extraction of antiquities and claimed a share of the proceeds. Notably, he gifted an Egyptian obelisk to France, which still stands in the Place de la Concorde in Paris. Under Khedive Ismail, 1863 to 1879. Khedive Ismail initiated the collection of Islamic artifacts and established Cairo's second Islamic museum within the Al-Hakim Mosque. This followed the earlier example of Sultana Shahjar al-Dur, who displayed the belongings of her husband, Sultan al-Salih Najm al-Din Ayyub, in 646 AH. He also ordered manuscripts gathered from mosques and schools to be housed there, later transferring them to the Khedivial Library under the supervision of Pasha Mubarak, now known as the Egyptian National Library on the Nile Corniche. Under Khedive Abbas Hilmi II, 1898 to 1914. The last Ottoman ruler in Egypt, Khedive Abbas Hilmi II, moved the Museum of Arab Antiquities to its current location at Bab al-Kalb, now the Museum of Islamic Art. He personally oversaw the Committee for the Preservation of Arab Antiquities, although no new antiquities laws were introduced during his reign. Under King Farouk I, 1936 to 1952. In 1951, King Farouk enacted a law regulating the antiquities trade that prohibited foreign archaeological missions from excavating without Egyptian government approval, banned the export of antiquities deemed strategic, permitted licensed antiquities dealers to sell to museums and local collectors. 4. Legislation after the 1952 revolution. Under Gamal Abdel Nasser, 1952 to 1970. Although antiquities laws saw little formal change, royal possessions, including valuable artifacts, were often sold at public auctions. Under Anwar Sadat, 1970 to 1981. Sadat issued decrees restricting the sale of antiquities exclusively to within Egypt. Antiquities exports became the sole prerogative of the state. All antiquities dealers were required to be officially registered with the Egyptian Antiquities Authority. Under Hosni Mubarak, 1981 to 2011. Law 117 of 1983 was enacted, which completely banned the sale and trade of antiquities, both domestically and abroad. Required anyone discovering antiquities on their property to surrender them to the state without compensation. Reclassified antiquities dealers as mere possessors with no right to sell. Impact of the 1983 law. This law effectively criminalized the antiquities market, prompting many dealers to engage in smuggling. It also created public resentment, as finders received no compensation, fueling perceptions of injustice. Conclusion. Over the centuries, Egypt's approach to its antiquities has shifted dramatically, from permissive excavation under Islamic rule, to foreign dominance in the Ottoman era, and finally to stringent modern legislation. The 1983 law marked the strictest phase, inadvertently driving a lucrative black market. It remains crucial that antiquities of national importance never be allowed to leave Egyptian soil. Recommendations. Reassess existing laws to enable regulated legal trade that curbs illicit markets. Strengthen enforcement against smuggling, particularly at ports and airports. Foster public appreciation of antiquities as national heritage, embracing Abdul Karim Abu Shanab's principle. All heritage is inheritance, but not all heritage is identity. Encouraging citizens to value antiquities beyond mere commercial gain.